You're listening to Tracy Henderson talking about the law here on Power Talk Radio 1460 and 101 FM. And Tracy's back with us now, and she has a special guest on the program this afternoon. Tracy, take it away.
Welcome, Professor Jacobson. How are you today?
Very good.
Thank you very much for coming on the show today, and thank you for your time. If you just joined us here on Power Talk 1460, 101 FM, we're talking about executive orders, their force and effect, historical use by many presidents over the years, challenges, and now we're going to focus on a particular order, DACA. And we're talking with, as Mark stated, a very special guest, Cornell Law School professor and blogger, William Jacobson. Professor, can you please give us a little bit of background about yourself for our listeners? You're a clinical professor of law and a director of securities law clinic at Cornell Law School. And I understand you specialize in securities arbitration. Is that correct?
That's correct. So I was in private practice as an attorney for 20 plus years. And then in 2007, I moved over to Cornell Law School, where I founded what's called the Securities Law Clinic, which focuses on issues related to investment law as opposed to national security. A lot of times people get that confused. So it's investment-related law, investment-related litigation. That's what my work has focused on, my practice career, as well as now being in academia since the end of 2007.
Very interesting. Some of my opposition counsel are having to do with the mortgage repurchase defense cases, and opposition is Lehman Brothers Holdings Incorporated. So I'm sure you're familiar with the 2008 bust. I'm representing some clients dealing with those issues. So interesting. It's a pleasure to meet you, Professor.
Thank you.
I understand your private practice was in Rhode Island as well?
That's right. So I was originally from the New York City area, but most of my career I was in Rhode Island. And then, like I said, in the end of 2007, I moved over to Cornell Law School. I went to college in New York State at Hamilton College, which is in upstate New York. And then I went to Harvard Law School and graduated in 1984. And immediately after that, entered private practice.
Wow, that's impressive, Professor. I'm only married to a Harvard man. So I understand you were the director of litigation for Harvard's Prison Legal Assistance Project. Can you tell us a little bit about that? Sounds interesting.
Sure. This was when I was in law school. When I was a law student, we had it was a group that we had that rendered legal services to inmates, and we only represented them in non-criminal cases and disciplinary cases. And so we would go into the prisons, which is horrible, and we would represent an inmate who had been written up on prison rule violation. And that was a fascinating experience because as a young law student, first of all, it's very hard to get practical experience. And then we would have to argue the case to a board of 3 people at the prison, 2 of whom were guards. So we were arguing a case where a guard had written up a prisoner for a rule infraction, and we're arguing it to a panel who consisted of a majority of guards. So it was just really good experience. It was very worthwhile. And like I said, we never represented anybody in anything that would be criminal in nature. It was, failing to move quickly enough or smoking where you shouldn't have smoked or something like that. And so that was one of my main aspects. But also in law school, I was the senior editor for our International Law Journal. So I've had a very varied law school career, and then in private practice, I focused on civil litigation up until joining Cornell.
Interesting. Do you enjoy being a professor instead of being a practicing lawyer?
In general, yes. It's a lot less stressful. I really do enjoy interacting with the students, but in private practice, you get that experience of winning a case. Most of my career, I was a plaintiff's lawyer on contingency fee, so you had to win a case. And when you won, it was very exhilarating. When you lost, it wasn't so much. So that part of it I do miss, but in terms of the stress factor, it's much less stressful, and I do enjoy interacting with the students.
So you're also a blogger, and your blog is legalinsurrection.com. Can you tell us why you started the blog?
Sure. It's actually an interesting story. My entire career in Rhode Island, I was non-political. That's not to say I didn't have viewpoint, but I was more conservative in a completely democratic state, and I was in private practice, and it was just better not to get involved in politics. So I kept my mouth shut and went along with my cases, and if you'd Googled me all you would have ever found is I had this case or that case and I won or lost or whatever the story was. And then in 2008, after I'd already joined Cornell, I was getting very, very frustrated with the blatant media bias favor of then candidate Obama. But I still didn't say anything, still didn't write anything. And then in late August of 2008, I was at a former client's house, someone who is now a friend, and we'd never discussed politics, even though I'd known him for 10 years. And he asked me, "Who are you voting for?" I said, "Well, I'm voting for John McCain and Sarah Palin." And we got into the biggest argument. For about an hour, we argued. Then finally, at the end of it, he said, "I've never heard anybody blame your side as well as you have. You should write about it." And then either he or somebody else said, "You should start a blog." And I had no idea what a blog was. I didn't read them. And so I looked it up, and I found Google Blogger, and it was free, and it was so simple even I could use it. And so I started to write and began to get attention and began to get other people linking to me. And fast forward, it's 8 years later, and we're still going strong. But now there's many people who contribute to the website, not just me.
Isn't it true that you had your 1 millionth visitor in less than a year?
Yes, that was a benchmark that I think a lot of people use to measure their success or traffic. And so, yes, things took off very quickly, and I learned very quickly within 3 weeks. So my first blog post was October 12th, 2008. By the end of October, I was already getting, I guess, what we loosely call hate mail. I was getting complaints to the law school about me, people trying to get me fired, and that kept up for a number of years, for probably 4+ years. Not every day and sometimes not every week, but a steady flow, harassment, steady flow of people who thought I should not be allowed to teach at an Ivy League law school. Threat, 1 year the university assigned a detective to accompany me to graduation because of threats. So, and this went on for several years. And the interesting thing, and people might think, oh, that must have been the equivalent of an anarchist or an Antifa or type person. And I say, no, actually it wasn't. These were mainstream Obama-supporting Democrats who were harassing me and threatening me. And a lot of times they just used their own name. They didn't even bother to try to hide. They felt they were entitled to try to get somebody fired or to bother you at work or to harass the professors you work with about how you shouldn't be there. And that went on for several years. And then all of a sudden, 2 to 3 years ago, it's like somebody blew a whistle and it mostly stopped. And so that was my introduction to the Internet.
Wow, that's powerful. Yeah, we're actually going to do a show on what crosses the line of free speech on college campuses in a few weeks. So it's a hot topic right now, especially with Berkeley's free speech rally coming up. I think it's either next week or very soon. If you're just joining us, we're on Power Talk 1460 101 FM, and we're talking with Professor William Jacobson, Cornell Law School, about executive orders, their force and effect, their purpose, and now we're going to talk about a particular order, DACA. Now, Professor, can we do a little bit of Civics 101 for our listeners out there who are not lawyers and talk about the basic premise of an executive order is where the presidential authority to issue this order actually comes from?
Well, the president, under the Constitution, is vested with the executive powers. That's right in the Constitution, and that implies the ability to run the executive branch. So if Congress passes a law and says that part of the executive branch shall, enforce these laws, the president also has a duty to see that the laws are faithfully executed. That's another clause in the Constitution. So certainly you put those two together, faithfully execute the laws, as well as power of the executive branch. I don't think there's a lot of dispute that the president has the power to direct the executive branch how to act. The question becomes, when does the use of that authority exceed the constitutional limitations? And that's, I think, always the question. I don't think there's any serious dispute that the president can tell a certain department, here's what you have to do to implement the laws. The question is, when does that, run afoul?
So the courts evaluate executive orders. We're not going to go into the details of it, but there's a famous opinion in Youngstown where they talk about where the president exceeds his authority. And I believe courts also use basic statutory interpretation. If it directly contradicts a statute or a congressional directive. It's exceeded its authority. But let's talk about the specific order that's been getting a lot of attention in the media lately. Let's talk about DACA, the Deferred Action for Childhood Arrivals program. Can you tell our listeners what this program is about?
Sure. DACA is not actually an executive order. A lot of times you'll see on TV that President Obama or President Trump signed an executive order for whatever it is. This DACA was actually just a policy announced by Janet Napolitano, who at the time was the Secretary of Homeland Security, on June 15, 2012. And she circulated a memo to U.S. Customs and Border and to ICE, Immigration and Customs Enforcement, and says, here's what you're going to do. So this wasn't even an executive order, literally speaking. This was just a policy announcement. And in that policy announcement, Janet Napolitano, I keep wanting to say Janet Reno, but that's the wrong president in the wrong office. Janet Napolitano announced that in the exercise of prosecutorial discretion, we are not going to prosecute people who meet certain criteria. And to kind of put it in basic terms, people who were brought here as children before a certain age, who've not had felony convictions, who's school, working, and who are not yet the age of 30. And if you are one of those people, we being Department of Homeland Security, is going to set up a procedure whereby you can essentially gain legal status, temporary legal status so far as you participate in this program, but you can actually obtain a legal status in the country, and you will not have to worry about being deported. And that's the policy that was implemented, and it's very curious because at the end of it, she says that this memorandum confers no substantive right, immigration status, or pathway to citizenship. And it's true that it didn't provide a pathway to citizenship, but it actually did provide an immigration status, and that's where I believe this exceeded the powers of the executive department, because it created a special class of people who were nowhere found in the immigration laws, who would be essentially exempt from the enforcement of the laws, not because of anything specific to the person, but because they fit certain categories. And that's what we call DACA, and it's been in effect since 2012 under this memorandum.
And recently, something has changed due to the new administration. It looks like by that same process, not an executive order, another memorandum issued by the current Department of Homeland Security rescinding DAPA and rescinding DACA in 6 months. Can you talk a little bit about that?
Sure. So this is, again, DACA is just a memo which said that exercise of prosecutorial discretion, which it wasn't. It was creating a new class under the immigration laws, which actually was contrary to the immigration laws. And what President Trump has said is that I am going to phase that out, that this never should have been implemented. It exceeded the constitutional authority of the Department of Homeland Security and President Obama. And let's make clear, this was President Obama's program. He just did it through Janet Napolitano rather than as an executive order. And that we're going to phase that out. There was no legal authority for it. And the people who really should be resolving this is the Congress.
Yeah, that was going to be my
Barack
next question.
Obama, multiple times, and there are great videos out there of him over and over and over again telling people that, look, I can't do this on my own. I've got to go through Congress. And then he did it on his own anyway. And so that was the issue that Trump said, that in a sense, just as Obama had always said, this is something that's within the legislative power, not within the executive branch prosecutorial discretion power. And Congress needs to resolve it one way or the other, or not resolve it. But we are going to phase this out.
Yeah, I think historically, and I might not have my years back because I'm a lawyer, not a historian, but they tried to pass some immigration reform, I want to say in 2003, again in 2011, and it didn't go through. And I believe some commentators say that was where the idea for this Homeland Security memo was born. It's the frustration that they couldn't get it through Congress. So they're supposed to have push immigration reform through Congress. Are you familiar with the court challenges, Professor, in the U.S. District Court of Texas on essentially the expansion of DACA into DAPA at all, or the expansion of DAPA itself?
Yeah, DAPA, I believe, had to do with essentially family reunification, things like that. So I'm not that familiar.
Yeah, I believe what they were trying to do is extend it to the aliens in this country who had children who were part of the DACA program. And that's where the Texas court case challenges were focused on, was the DAPA part of it. It is true that DACA was never challenged in court, but what was interesting was DAPA went all the way up to the Supreme Court, and it was affirmed 4-4 that it's improper that because the Immigration Nationality Act does not permit the reclassification of millions of illegals, of aliens as lawfully present. So I think that's what your point is that these memorandums should have gone through a different process, which is the congressional development of a bill. Now, what's interesting in the news, professors, and I think it's on your blog, is Janet Napolitano is among several of the key folks, states, educators who are suing the Trump administration for his phasing out of DACA. Can you tell us more about your thoughts on that subject?
Sure. Well, I think despite Janet Napolitano's memo saying this creates no substantive rights, they're claiming that it did in fact create substantive rights. And a lot of the arguments that we're seeing in California and in this lawsuit brought by, I think it was 14 attorney generals filed in New York, the argument is essentially the argument that we saw in the travel order cases, which is maybe what the president did would be lawful if it were another president, but this president has discriminatory bias expressed in words during the campaign that renders this an unlawful, intentional discrimination, either based on racial or ethnic or religious grounds. And therefore, we have this curious thing, which the Supreme Court may or may not ultimately decide in the travel order cases, which is this unique claim that the actions taken by Trump, if taken by another president, would be constitutional. But because they're taken by somebody who on the campaign trail allegedly made negative statements about various groups, all of a sudden that bad purpose becomes a constitutional violation. I don't think the Supreme Court's going to rule that way. I'm not sure they'll ever rule on it whatsoever in the travel order cases, because apparently the prior travel order is going to be rescinded soon and a new one implemented. So I would not be surprised if the Supreme Court says there's nothing for us to decide anymore. But that is what's going on here. The argument is that because of comments Donald Trump made about Mexicans, and a lot of times his comments are being twisted and exaggerated, or other groups, that all of a sudden this becomes unlawful discrimination. And that's the premise of a lot of these lawsuits.
Professor Jacobson, this is Mark. I just want to throw in a thought here and maybe get your reaction to it. If the Supreme Court actually did take up that kind of a question that, well, this is unconstitutional because this president, we believe, has evidenced bias in his words in the campaign, that would seem to be a pretty doggone slippery legal slope that would set some interesting precedents that constitutionally I don't know that you could ever recover from.
That's right. Normally, courts will consider legislative history, will consider that history, but I'm not aware of them going back to the campaign trail or prior to the campaign trail and saying that merely because you made a comment along the lines of Mexico is not sending their best people. I think that was his comment in 2015 when he was very early in the campaign, that now all of a sudden you can take no enforcement action along the border with Mexico. I mean, that would be a crazy result. How far back are you then entitled to go? And so I don't think that that's ultimately going to fly. I think that in the travel order cases, the fact that the Supreme Court did, at least on a temporary basis, mostly overrule, put a hold on the lower court rulings, is a signal that the Supreme Court recognizes that once you start going back to comments made on the campaign trail, why not dig through high school newspapers? And if somebody said something in high school about a particular group or particular subject, that all of a sudden that person becomes president and now can no longer fulfill the executive function. So it's a very slippery slope, because once you start going beyond that narrow legislative or executive history as to how something came into being and going back into somebody's prior life seeking to pick out comment, then I think it's almost endless.
Yeah, and just to add to that, from a basic evidentiary perspective, from a trial lawyer's perspective, the courts consider the record. You have very specific rules as to how to get statements in and what is admissible, what is hearsay and what is not hearsay. So it really surprised me that nobody has taken up that position and taking something that he said on a campaign trail and trying to admit it as evidence of bias. It just makes no legal sense to me whatsoever. It's a great question, Mark. Well, so in the end, it sounds like, Professor, I don't want to put words in your mouth, but your position on DACA is that it's not an executive order. It's a memorandum from a department, and whether or not it's even constitutional is not even a question in your mind. Is that correct? What are your thoughts on that?
That's correct. I think it clearly isn't. The executive branch doesn't get to essentially pass a law on its own. And you talk about history. I mean, we have all of these statements from Obama saying he can't do this, and then they did it anyway. We have the history of them trying to get it through Congress, and that's the best evidence that the executive branch recognized this was something for congressional action, is that they actually tried to do it. Yeah. And you combine those things, I think it's pretty clear that this was an overreach. And what a lot of people don't understand is whether or not something is constitutional usually has nothing to do whether it's good policy or not. It would be completely consistent for somebody to say, look, I have compassion for someone who was brought here as a young child and knows no other country, and maybe we need to do something about that. But that's not for the president. You can't just do it. That's not our system. Got to go through Congress. And that's what people don't understand. They assume that if there's a negative result, it must be unconstitutional, or a result they don't like, it must be unconstitutional. And that's not the way it works. You can vote people into office who will pass the laws that you want, but the president doesn't get to do it on his own.
I'll tell you this much. Every time I saw Obama say, well, that's something our system doesn't allow me to do, I would say, okay, here it comes. He's going to do it anyway.
That's right.
And a week or 2 weeks later or a month later, that's exactly what he would do. That was always the signal. That was the tell.
That's right.
Yeah, that's exactly the point, Professor. I really appreciate your insight. And again, we are talking to William Jacobson, Professor of Cornell Law. We appreciate your time, sir. We appreciate you sharing your expertise.
Great. Thank you very much.
Thank
Bye-bye.
you. Folks, you're listening to Hot Topics on the Law, breaking them down with attorney Tracy Henderson on Power Talk 1460 101 FM. We'll take a short break, and we'll be right back.